Hello, welcome everyone to LexMaker. Today we're in episode number 2, where we're discussing legal frameworks for decentralized autonomous organizations. The topic is a bit broad, and that's on purpose. We actually have 2 guest of honors. We have Miles Jennings from A16Z, where he's a general counsel. Maybe I'll let it to you guys to speak more about yourselves. And we also have David Kerr, principal of Cowrie LLC. I might be mispronouncing that, but they produced this really good research paper that SCS has been sponsoring. So we are actually pleased to have you guys here, and we're thrilled to share this. To have you sharing these things with you. So without any further ado, if anyone wants to ask any questions, please raise your hands or write it in the chat, and we'll do it. And yeah, now Miles, you can take the mic.
All right. Yeah. Thanks a lot, Juan. Dave, you want to do a quick intro?
Yeah, that sounds good. My name is David Kerr. I obviously co-wrote this paper with Miles in relation to solving, a couple of really pressing issues for DAOs going forward in the space. It's a relatively new concept, and tying into entity structure, existence, operational questions, taxation. There's a lot to unpack, and so Miles kind of invited me in a few months ago, 7-8 months ago, onto some issues that were going on in the DAO space, and we kind of put this paper together as a research tool to kind of formulate our approach for how to go forward, advising clients related to how to operate as a DAO. My background is in taxation. I worked for Ernst & Young for a period of years, and then I started my own consulting shop. And Miles was a pretty large factor in my deciding to go full-time crypto, just because there were so many nation issues, novel issues, and just so much work to be done that it became pretty clear that my background in tax, mostly in gaming and telecom, was highly applicable to the treatment of US taxation and some of the international issues facing DAOs. So that's my background, and then I'll send it over to Miles for his.
Yeah. So, happy to be here. Before this, I'm currently at A16Z as the GC of their crypto fund. And prior to that, I was a partner in Latham & Watkins Emerging Companies and Capital Markets Group. So I basically spent the last kind of 4 years working with startups in the space, going from incorporation through kind of token launch and then decentralization stuff after that. And also kind of, working on the investor side, representing Paradigm, Parify, Pantera, Dragonfly, Co2, and others. And basically, so got a very good feel for kind of how, the investment frameworks are set up. And, one of the problems that, some of my clients started having, for instance, I worked on the Uniswap token issuance, was, Treasury management and, dealing with kind of issues that have arisen with respect to, DAOs in operation. Obviously, Maker has a very long time DAO and that has been in place for a long time and has done some interesting structural work over time. Obviously, the problem is also quite large in that there are, any number of formulations, countries, jurisdictions to deal with. But the targeted problem that Dave and I were really looking to solve was for DAOs that were basically formed by developer corporations that were primarily in the United States, and that were either going down the path of kind of a foreign entity foundation or an entity-less structure. And so we're primarily focused on U.S. issues here. There are other jurisdictions, and also, there are other types of DAOs, right? We've mainly focused on, DAOs for decentralized finance protocols, and not, investment DAOs or social club DAOs. All of those are kind of outside the scope of this and need kind of, a different analysis. though, there are some kind of carryovers that could potentially, work in those scenarios. So here's a quick disclaimer on kind of, this not being legal advice, and then we'll just kick into it. So as many of you are probably aware, there are several key issues facing the two main DAO structures that currently exist, which I categorize as being kind of entity-less and, the foreign foundation route. On the entity-less side, what that really is, right, is a developer C Corp in the US, creating the technology, launching their, protocol, and then launching the governance protocol, issuing, tokens, and that kind of being it, right? No actual legal entity formed in any jurisdiction. And so, the issues that we've seen arise from that, right, are that you don't have any legal existence, which, makes it impossible to kind of represent the DAO as a legal entity. That means you don't have any ability to pay taxes, right? Taxes do arise for DAOs in several instances, use of the governance tokens by the DAO treasury, including liquidity mining, and, income that the DAO generates through, operation of the protocol. All of these are potential taxable events that would necessitate tax filings if there was a legal entity, and in the long run, we think that taxes is really going to be an area where the U.S. government at least really kind of tries to make moves on the industry. You saw that somewhat with the infrastructure bill, where one of the big things was driving tax compliance amongst users of crypto, and I don't think they really realize what the pot is in terms of treasuries. But if you look at a corporation like or a protocol like Uniswap, right, that treasury is worth or was worth multiple billions of dollars. And so, it's obvious that from my perspective, that the government's going to be ultimately very focused on this. And as a result, I think, having kind of a method of complying with tax obligations is a fairly important one. Unlimited liability is also a fairly scary one. Under normal corporate structures, there is typically limited liability for the shareholders, and even for the officers and directors of the company. Whereas here, with DAOs, when you don't have a legal structure in place, everyone is potentially a member of the DAO and could potentially be sued. And maybe, like, we obviously have not seen yet what the practical application of that is going to be. But if you were to look at, Pool Together got sued recently in a class action where, the investors were named, Compound was named, the founder was named. Even if that case is spurious, and I think if you looked at kind of how they set it up, it certainly looks that way. It's still going to take time and money to pay for, filing motions to dismiss. If you get through a motion to dismiss, right, you're then talking about discovery, and a long kind of line of litigation. And I think that that potential to hit founders and prominent members, particularly those that are active in the DAO governance, I think the likelihood is just very high. And as a result of that, I think it's really necessary for the industry to kind of coalesce around potential options to limit liability. The final one is an inability to contract, right? One of the, I think, problems that I've seen come up with a lot of my former clients and a lot of portfolio companies that I work with now is, these protocols, like this often comes up in trying to get, in grant programs, in code audits, things like that, where people have difficulty contracting with service providers because they don't have a legal entity. Now, sometimes obviously a lot of those arrangements just end up being that they pay, on chain and kind of the relationship is what it is. But, there's a reason why we have legal contracts to begin with, and it's to ensure that both parties act in accordance with kind of the framework that they've agreed on. And, you know, DAOs are really taking the bad end of that arrangement in when they don't have legal contracts, because they're obviously paying the money, but they have no guarantee that they're going to get services provided. So as a result of that, I think that, you know, grant programs and you know, other services that DAOs have used so far are not really being held to account to deliver on, you know, potentially the promises that they make to the DAO when they, you know, submit their proposal for grant. Skipping over to the foreign foundations, right, I think that the most popular destination has been the Cayman Islands, given their flexible tax framework. But you know, a lot of the foundations that have been used are typically not kind of placed within the decision framework of the DAO. What I mean by that is, you know, oftentimes the DAO and DAO governance will all be on chain, and as a result of that, you know, the Cayman entity that is formed as a foundation isn't really you know, isn't acting on behalf of the DAO, or doesn't shield the DAO from limited liability, right? In order for those foundations to actually shield the DAO members from liability, they would actually need to be the ones that enact the DAO decisions. And so, you know, there are examples of that where you have, you know, the DAO essentially decides to do X. It tells the foundation to do X, that foundation then does X. So, you know, we have seen that in place, but that kind of setup, you know, does raise some questions around, you know, decentralization, because, you know, if you go back to 2018 in the DAO report, right, the SEC kind of stated at that time that, you know, the ability of certain members to veto, you know, decisions of the DAO was determinative that there wasn't decentralization. And so as a result of that, right, I think that, you know, if the SEC got around to kind of really looking at this framework, I think that they would ultimately say that foundations, you know, that are set up that way, you know, do cut against the decentralization analysis. You know, in addition, right, the foreign foundations are also difficult to set up. You often have to have, you know, people on the ground in that jurisdiction acting on the board. And then lastly, you know, I think that it's, you know, potentially politically unfavorable in the United States to go with the foreign route, because ultimately, right, I think that, you know, in order to encourage, you know, legislatures in the United States to, you know, support this industry with, you know, smart regulation, right, I think that they'll obviously want to see the economic benefits of providing that kind of, you know, flexibility accrue to the United States. And I think that if, you know, if the, you know, typical pathway that every company is using is to offshore and kind of end up locating itself in, you know, the Cayman Islands, then, you know, obviously a lot of the economic activity that would have otherwise remained in the US is kind of moving out. And so you can just see how that would be, you know, potentially a negative set of facts that a congressman would kind of, you know, speak to in trying to get, you know, more harsh regulation brought against the industry. So, you know, from a political perspective, I do think it's advantageous to stay here. And that's not to say that you know, everyone around the world should be, you know, coming and forming one of these in the United States, but to the extent that DAOs have a significant presence in the United States, I think it's worth them considering whether or not an UNA, you know, makes sense for that US portion. Moving on to the, let's see, existing legal structure. So, you know, all that being said, right, you know, I very much understand that the Cayman structure is probably the one that offers the most, or Panamanian structure are the ones that offer the most certainty at this point, you know, given that there's just not a very clear pathway anywhere else. You know, when Dave and I started on this project, we basically, you know, went through and started with first principles about what, you know, what these entities needed to be. And, you know, a lot of those considerations took into account, right, whether or not people could remain anonymous, whether or not, you know, there was centralization and whether or not, you know, the inherent corporate governance requirements of those, of the entity required, you know, people to be in charge and people to be able to veto the DAO. So, you know, in thinking through those, right, you can quickly kind of check off that, you know, C Corps and LLCs and limited partnerships don't really work because, you know, all of them, well, the LLC and the limited partnership have, you know, issues with respect to pseudo anonymity, right? You can't become a member of an LLC without disclosing who you actually are. The LLCs need to file tax reports for each individual member. It's just not a workable framework for widely held anonymous DAOs. You also look at the Corporate Transparency Act, which is currently being enacted by FinCEN, the rulemaking that Congress previously approved. And that is potentially going to require disclosure of LLC members and partners and partnerships to the government. And so again, if you have a anonymous membership group, it's fairly difficult to kind of see how you would get around those issues. Finally, it's like interests in for instance a C corp, right? All of us have spent a long time making sure that these tokens aren't treated like shares, because ultimately that would make them securities. And if you were to set up a C corp, issue people tokens, give them a right to the profits of the company, give them voting rights, and there was a secondary market, that's just, that just means they're shares and are securities under Supreme Court precedent, specifically Landreth. Finally, a few people have been kind of, researching co-ops and looking into the use of those, and both a Wyoming DAO and co-ops, I think, have good use cases within, DAOs generally, right? I think that they both have specific drawbacks that make them unsuitable for largely distributed and widely held DAOs where you have anonymity. With co-ops, that kind of comes up with the fact that you can't have freely transferable interests, and obviously that would be a deal killer for a lot of protocol, particularly DeFi protocols. So, Dave?
Yeah. I think to kind of summarize Miles's overall points about the existing options and how we kind of started our analysis to find a suitable entity structure, is to kind of take a look at just how diverse the DAO environment actually is. There's a significant amount of different types of DAOs, different use cases, different participation requirements, different governance models. And so I think there's a lot of times a pressure to decide what's best for a DAO when we're dealing with such a wide divergent entity. And so what we kind of tried to do with the formative principles was establish what was really important for the DAOs with facts that were more similar to ours. Our goal, hypothetical, not a specific client. And so that's why I think a lot of times with the co-op model, Wyoming model, Caymans is certainly viable. And I think the other thing we want to look at is also time. I mean, this has been the environment around DAOs has been growing over the past 4 or 5 years, but there's not a huge amount of legislative direction on the way to go. And so some of the decisions that were made 4 years ago may not be the decisions that are made now, but it's because there's a certain amount of clarity from Congress's involvement in this process, from the decisions that have been made from the SEC and the commodities organizations, and just in general the information that we're getting, the CFTC, and so taken as a whole, there's a lot of different areas to look at. And so one of the things to keep in mind is that a lot of these DAOs have been handed over to decentralized membership. And so when we're trying to actually onboard one of these for me, a client, and Miles and I kind of share a few situations where we're working to take a step forward on what we put out in the memo into the real world. One of the areas you have to deal with is that the clear path that Miles just delineated isn't exactly an option when you have decentralized governance. There's certainly a history of the benefits of centralized operations in terms of finance, in terms of business, in terms of how you make decisions. And when you turn that over to group decision-making, communicating these issues in a way that's clear to people, that makes sense to them, that provides them the ability to make an informed decision around entity structure and to confine their behavior within those rules. this is a difficulty that goes beyond a theoretical solve. It's an actual communication issue about education and involvement in the community. And I would say since we published our memo and gotten started actually putting some of these into practice, the area that's slowing us down is not the theory at this point. It's the fact that we're trying to find ways to make sure that the messaging is done that involves the community, that it's community driven, that they're involved in the decision making for how to make these decisions, how it fits within the protocol. And we're living that decentralized experience as somewhat external advisors. And so that is a huge point of slowdown and emphasis, because it's one of the reasons why the UNA is such a valuable tool in that when it doesn't require a particular amount of formalization around the members to join one. And when we were looking at how a decentralized group of individuals was going to actually make an affirmative assessment to become an entity, that was a huge part of the test as far as limitations of other structures and how to actually get one of these off the ground. And so the history of the Unincorporated Nonprofit Association was hugely informative in providing a background where it was more of an informal membership. And I've seen through the chats, there's been some questions about co-ops and some differences between the co-op structure and the DAO structure and the UNA. There's certainly an overlap on a Venn diagram behind some of those concepts. A lot of the UNA's case law that we looked at when we were formulating this first opinion involved co-ops, particularly in Texas. A lot of the co-ops there were actually organized as an UNA, as we call it. And so there's certainly a lot of grounds for there to be overlap. And so as far as our decision making for what would work and why we chose the Unincorporated Nonprofit Association, it was because when we were going through the fact patterns for what existed under the law and what had been conceived under the law, this was what really stood out as meeting the test for an entity to get the benefits that Miles was talking about as far as existence, as far as paying taxes, as far as limited liability, in a manner that was consistent with their rather informal association, which isn't to mean that a DAO is not a valid organization. It's not a mark on validity, say it's more informal. It's that by holding governance tokens and participating, that's a little different than signing an agreement to join an entity or a partnership structure or establishing how all that work to come together. And so the ability to have kind of an informal onboarding that is dependent on conduct is hugely helpful for actually being able to even form an entity. So if we can get the next slide going, I'll start taking you through some of the, here we go. So when we started doing the research, what really popped out was that the UNA, the Uniform Act around the UNA, has been adopted by several states. It's very helpful because it kind of provides context and how you can interpret the UNA. Like it's very instructive and it's relied upon by the legislatures who adopt it to kind of follow some of the rules. So even though it's inherently non-transferable, you can opt out of that by choice. And so there's a lot of clarity on how membership gets formed or how adoption exists or how the legal entity really comes together and functions. And so there's also a lot of non-UNA versions of unincorporated nonprofit associations that have some protections from a liability perspective. Not to get into the overall history of corporations in America, but or from Rome or England or wherever you want to start. But there was a time where there's a significant difference between the treatment of a general partnership and a corporation entity. It was the ability to have an entity, a legal existence through the organizational structure that provided the ability to sign contracts, that provided the ability to get limited liability protections. And so, you can look at the writings of Adam Smith and any number of contemporaries from that time period around the joint venture companies, and just the reason why any of this matters was that it provided a legal entity for avoiding liability and for operating as an existence form. Historically, that has become less meaningful as the protections of that entity structure have been expanded to non-incorporated entities. And so from a functional standpoint, when you're able to exist for contract, when you're able to have limited liability protection, when you have legal existence, when you have the ability to pay a tax return as an entity, you've kind of crossed that barrier into basically being a corporate form from a practical purpose. And just to take one kind of pause, because I know we have an international audience here, and this is a question that comes up a lot, is why are we talking so much about US securities law and US tax law and US entity law when DAOs are international organizations that may or may not have any ties to the US? I think Miles alluded to the fact that certainly you wouldn't necessarily seek out the US for your entity status, given the option of not. But the reality is that the US government, through a variety of means, has a very wide interpretation of when its securities laws apply based off of its citizens participating in the transfer of those securities, and a very wide view of taxation based off of, impact on the US sourced income, effectively connected income, the ability to do operations in the United States. So even if you were to avoid doing a US entity structure, there'd still be a tax potential around your operational use in the United States. And so, to Miles's point, kind of from a higher level on why the US makes a lot of sense, is that because of those levels of risk and their activity in the space and the connections that come from the US in a lot of situations, it presents a pretty good risk option to utilize the US as an entity home, because the benefits are clear in terms of, some reduced complexity around how you would figure out the treasury taxation, who's your taxation authority, what your tax would be, what your entity structure should be. It closes a lot of the loops and provides some amount of value to the members, not just from an anti-risk standpoint or a reduction of risk standpoint, but also from, an operational clarity of purpose. There's certainly a lot of benefits to the United States in terms of being a free society with obvious, not a perfect situation. It does have issues, but from a grand sense, it does provide free speech. It provides free ability to interact with ideas. And that's a huge fundamental part of a DAO being able to operate. And so there's some amount of higher level benefit to the US besides just the clarity and regulations. And so that's kind of my sales pitch for why the US is so prominent in these discussions.
David, I wanted to also use the pause. I think Robin has a question.
Sure. Thanks, Johan. So my question is related to securities, using of governance token. Is it a security or not, right? Because if we keep the governance token completely separate from the main entity, so that means it would not be, if it's sort of a non-profit, it is not tied to the entity. That means there is not too much incentivization for the members, right? So I'll just take an example of Maker, because I feel the way Maker works, that's wonderful, a really great governance token, because it the Maker token sort of helps the protocol in case whenever it needs money, and if there is surplus, it helps then the members by purchasing the Maker token and then raising the price, right? So I think here you see the governance token is somewhat very completely tied to the core foundation entity and helps that. So in that case, do you count, if you have these type of governance tokens, do you count them as securities or not?
So what I would say there, right, is your typical agreed that governance tokens, particularly Makers, right, have special utility in the sense of how it works in the Maker protocol. And the big thing that you don't want to see them is it be compared to shares and be securities, right? There is case law, Landreth, in the United States that says that if a token has a right to vote and a right to profits of the enterprise, right, and there's a secondary market for it, then that token is technically a security. And so one of the issues, right, that we have with generally with some protocols is that the use of kind of profits to buy tokens out in the market and burn them is potentially an issue under securities laws, because that could be construed as being, a distribution to token holders by means of kind of inflating the overall token price. And so as a result of that, look, it's not clear, right? This no case has been brought around, under this theory that kind of a buy and burn is a distribution. But if you look to, companies that publicly tradable companies in the United States, right? Obviously, share repurchases and share repurchase programs are something that they engage in, and so we would think that there's a potential that the SEC would draw the analogy between the two. But to speak to your more basic point, right? The nice thing about the UNA is that a normal unincorporated nonprofit association, right, like the NBA, right, or any association, right, isn't that you don't have shareholders, right? The members of that association don't hold a security that give them the right to be members of the association. And as a result of that, that's obviously very different than an LLC where members have membership units. And it's very different from a C Corp where the holders have, shares in the company. And so as a result of that, I think that the UNA, does a good job of distinguishing itself from, normal corporate structures that involve, the investors in that structure holding securities.
Yes, and referring to the UNAs, I think Xavier had a question in the chat. If you.
Yes. Do you hear me?
Yep.
Yes.
Yeah.
Yep.
So thank you very much for this presentation, and especially this paper that was interesting. My question was, are UNA recognized internationally? And if they are not perfectly recognized, could we imagine that a DAO has different status in different jurisdictions to protect for the same reason, if there were other countries that would have a potential risk of regulatory reach?
Yeah. Sorry, what was the question?
So I guess it's if UNAs are recognized internationally.
Sure. It's obviously a very complex question, because you'd have to look at every jurisdiction, right? But generally speaking, the role out here that we envision, right, is we're really just kind of focused on the US. There are structures in Switzerland. There are association structures in Switzerland that are very similar to the UNA statutes in the US. And so, looking into that, we haven't kind of gotten that far in this process yet as to whether or not you would need, a separate UNA in every jurisdiction. Obviously, that seems pretty unworkable, and isn't something that, really that C Corps or, other entities do, right? Typically, they have an entity located in one jurisdiction, and that's respected around the world. It's even a complicated matter for, just states within the United States. They don't all have the same statutes with respect to how they have, UNAs available. And as a result of that, right, there is some tension between states in terms of what they're going to make permissible and what they're going to respect in others. The thing that you would do, right, in kind of setting up a legal framework for this would be that you would set up the UNA in the United States, and then your terms of use for anyone using the protocol, right, would be to require them to submit to the jurisdiction of the United States, and specifically the state where you formed your UNA. And that way, if you were to if there was to be some harm suffered by a user, right, they would be required to bring that action in the jurisdiction of your choice. And that should help kind of limit the risk from, foreign issues. The other thing is, right, is that ultimately, I think that the answer that it's too complicated and that these are cross-jurisdictional entities, right, isn't really one that's going to persuade regulators that they don't need to regulate, right? To regulators, kind of, they're a hammer and the world is a nail. And, there's a lot of these kind of conversations and a lot of this thinking has already been done when the internet was first created. And, at the outset of the internet, right, you had a lot of kind of cross-jurisdictional entities that were operating and kind of, and there were all sorts of kind of regulatory complications. And, eventually a regulatory framework, was applied, and that's where we ended up today. And so we think that there's, most likely outcome is a similar course of events here.
Thank you.
Nice. Oh, sorry, did you want to? Okay, I think Kianga has a question as well that was more or less the same as paper Imperium had before. I don't know, Kianga, if you want to jump into the mic, or I can read it. Happy to.
Oh yeah, I was just in terms of capital appreciation of the token, if that would be considered distribution of profits, or are we talking about more specifically a different type of asset transfer to the holders?
Well, do you mean if you were to distribute treasury assets from if the DAO were to decide to distribute treasury assets, or what?
Potentially, I was just kind of keying it off of your analysis around just the discussion you've had about distribution of profits. And I was just wondering if by holding a token that appreciates, a token that has a secondary market and it appreciates, if that's considered a distribution.
No, I don't think the inherent
in
appreciation in the price of the share, in the price of the tokens, isn't something that puts you off sides with respect to securities laws. It's the actual distribution of the profits of the enterprise,
right, okay.
or the actual having a right to the profits of the enterprise, right? So if to put it more like, Maker's situation is I think more unclear, but if you were to have a DeFi protocol that essentially all fees that were accrued to it, if they were to just distribute those to token holders pro rata, right, that would be a serious factor, I think, in the application of Landreth to that arrangement. And I think that it would significantly increase the risk that those tokens were deemed to be shares / securities.
Thank you for that.
All right.
Yeah, I just saw one come across. The buy and burn is at risk with that strategy. Yeah, I mean, that's kind of what we're talking about operationally. Some of these items, that some of the conduct on the part of DAOs is a securities risk. And then, it's also an entity risk, depending on what type of entity you frame yourself. There's behavior that's outside of what's allowed for the organization. And so yeah, that's where the high risk levels come from, and that's where consideration of what member distributions look like, or distributions at all, activities done by the protocol in relation to member benefit. All of that needs to be considered from a risk standpoint in terms of what's allowed and what's not. It's not a super defined area, but there's certainly clear indications of what's more risky as opposed to less risky.
Makes sense.
Can an UNA hold property and sign contracts? It sure can. That's one of the benefits of both parts of it.
Yeah, Dave, why don't you run through the advantages here, and then we'll talk about the disadvantages, and then quickly jump through the examples, and then we'll get to more Q&A.
Yeah, that sounds good. So we got the list right here. It's simple formation requirements. You can kind of look back in time at the deployment of the governance contract. Obviously, you might have to file an out-of-period return, but it's not an insurmountable obstacle. The lack of board or other centralized hierarchy is really important, not just from it's in good faith with how DAOs operate, but that's also an avoidance of some of the securities additive risk that Miles talked about when you have the ability to override your DAO, or have the ability to have off-chain decision-making that circumvents the DAO. This is not possible under the UNA, or at least it's not a requirement. There's that centralized hierarchy, and so there's an opportunity to have a real clean, decentralized form of governance. No membership limits is obviously big. Some of the more restrictive LLC models around investment do have limits of how many people can be a member. before you have to meet certain registration requirements. And so this is not in line with that. There's no membership limits here. It's transferable, and so that's a huge benefit in terms of moving the tokens. And so obviously the membership it needs to dictate whether or not it's allowed. It's an opt-in. It's not automatic, but it's also a surmountable problem. And then, you know, the limited liability, and this is a legal entity separate from its members and determining enforcing rights, duties, and liabilities. And so, you know, and to take it to my area of specialty, the tax side of this, what we're trying to really solve too, is one of the questions that I get a lot from DAO community members in relation to the benefits of the UNA is, well, why should an international community be forced to pay US tax? And I would reframe that slightly differently. We're not talking about the tax impact related to the governance tokens themselves. So to whatever degree, you know, people have the governance tokens, you know, if it was given as an airdrop or how they got it, there's a tax on an ordinary income for the receipt of that. And then if they sell it, there's a capital analysis to be done, whether it's a capital gain or loss in relation to that ordinary income. That still exists with the UNA. What we're really talking about is behavior that is not necessarily allowed under securities law, not allowed under nonprofit definitions, and the Treasury. Well, the Treasury has any number of ways of having tax realizable events. A hard fork will do it. A diversification of assets will do it. Anytime you change one form of you know, crypto for another, that's a swap that's taxable according to the IRS. And so there's a lot of times where the Treasury has to pay tax and has a tax bill. And what this does is it provides kind of a clear path to how that Treasury tax ramification, that event should be taxed. And at an entity level, there's a clear amount of tax to it. Now there is double taxation, so any distributions would also be taxed if you'll receive the distributions. But as we're talking about, there should not be very many distributions, if any. And so it's really kind of a complementary overall to the tax side. And so really what we're talking about is that the Treasury itself has a tax obligation in relation to its activities. And that would be the same, regardless of the entity structure. It would be based off of geographic activity and whether or not there was a US tax impact. But in the memo, we go into a lot of detail around this. Deciding who the taxpayer is, whether it's the entity, whether it's the members, whether it's the founders, those are the only options, and none of them are good from a logistics standpoint. Whereas getting an entity structure that elects for taxation as a C Corp solves a lot of areas that don't have good answers otherwise. And so it's really beneficial. And so it's not that it's an application of US tax onto the members, it's an application of US tax onto the Treasury and the Treasury and the entity as a whole. And so that's a big distinction, because a lot of times people are afraid that they're getting taxed at the US for no reason. And that's not in relation to the governance tokens they hold as individuals.
David, can you maybe give an example of the interests being transferable for us mortals that don't speak the legal lingo that well?
Oh, sure. I mean, it's as simple as a swap, right? I mean, the governance tokens is inherent to, you have a right to a lot of times vote in these DAOs based off of holding a governance token. Well, you transfer the governance token to somebody else, now they have a right to vote in the DAO. So you can freely move the governance token in this context. And that method of membership would be allowable under the UNA, because there wouldn't be a limitation on who could be in the organization and then the method in which they transferred their right to participate in the organization. It would be complementary to the moving of the token would allow the membership in the UNA to change. And so that's a really good.
In the UNA, you would not be able to transfer it, right? So you would not be able to sell the governance token.
No, you can, right? So you can set the governance token, right? You basically have a lot of flexibility with respect to your articles of association for an UNA, right? And so you can set it up so that tokens can be freely transferable. You don't need to have someone submit their name or sign anything. You know, it is as simple as swapping tokens on Uniswap. that would be the transfer of your interests in or your membership in the UNA. The other thing here that we don't really have, right, it's kind of talked about on the flexible governance, right, but as specifically like using Maker as an example, right, there are a lot of sub DAOs, and you could set that whole framework up in the Articles of Association for an UNA, where there were various DAOs and either an individual that was responsible for ultimately kind of coordinating there, or making decisions. So there's a lot of flexibility in terms of setting up a a very kind of distributed system. So the one kind of disadvantage that we have come across so far with the UNA is nonprofit status, right? The UNA stands for Unincorporated Nonprofit Association. Nonprofit doesn't mean tax exempt, right? So it doesn't mean that you are not a taxable entity, and so the to qualify for it, the standard is a lot lower than what it is for being tax exempt, and it varies by states. Typically, the restriction around nonprofit status is one of distributions of profits to members. And so, if you look at the bottom there, there in California, the UNA statute itself, specifically says that UNAs can engage in for-profit activity. But again, the restricted activity is really distribution of profits to members. Now, given that that is already something that is potentially prohibited under Landreth, which I mentioned earlier, right? The UNA doesn't really change kind of the existing paradigm with respect to the risk of transferring profits to users. At the same time, right, this is something that we're going to actively lobby to get rid of in the United States, and hopefully in several states, convince them that it's not necessary to have that limitation in place. Now, one of the reasons for that, right, is that what we hope to do is basically establish, UNAs at the outset that behave as responsible corporate actors, right? That the fear that we've kind of heard from people so far is that you don't want a bunch of, essentially shell corporations out there with no money, no financial ability to pay for harms that they might cause, and then they go out and recklessly cause a lot of harm. And so I think that one of the things that we're going to need as this industry evolves over time, right, is to prove that decentralized governance protocols can behave responsibly and can mitigate harm, and we've already seen that, right? When there's been smart contract breaches, you often see protocols make people make people whole by distributing additional governance tokens to them. So I think that that ethos is already like fairly prevalent within the industry, and so just showing kind of regulators how that works and how that people are behaving responsibly will do a lot in convincing them to make the UNA statutes more flexible to tailor to DAOs. So we'll go through a couple structures here just to give you guys a sense of kind of what this could look like. There's the fully wrapped concept, right, which is essentially the entire DAO is an UNA, right? So the each token holder is a member of the UNA, and you essentially wrap the entire structure. In this, you'll see that we have an outside 501c4. This is an entity that you could create outside of the UNA that would potentially engage in lobbying efforts. That would be potentially a nonprofit. So this is just to give you a sense of kind of the overall kind of combination that you could use to essentially give the UNA members limited liability protection, right? You could also have sub DAOs underneath this, where there are UNAs that are formed that are separate from the kind of main UNA, and if that separate UNA, for instance, like Maker's legal DAO was an UNA, right, you would expect it to have kind of some allocation of grant funding to kind of continue operation, but really the idea being, I know that with a lot of the Maker structures, people have used LLCs for these sub DAOs. This would potentially give you a way to have sub DAOs that could maintain anonymity for their members. Dave, why don't you kind of talk quickly about the siloed structure, and then we can open it up for questions.
Yeah, so one of the ideas that we had in terms of, obviously, there's some concern about having an UNA adopt one of these without a clear exit strategy. The law could change. And even though the UNA looks very good for right now, if there's all of a sudden a new, crypto entity structure created, which seems unlikely, but it's certainly possible, then you might be in the wrong spot. And so there was some concern about how you could still limit your liability, get some of the benefits, pay your taxes. And that's where the kind of the silage structure came up, and that there's the fundamental dominion and control necessary to establish an individual entity exists within the technology of a DAO at multiple layers. So depending on how it's constructed, you may well be able to wrap just the treasury or just the operations in an UNA structure for the purposes of filing a tax return, reducing your limited liability to some extent. And the reason why that's possible is that they have different functions. I mean, the chart kind of lays out how it starts with the DAO members holding the governance tokens. And I think from picturing it, it might be easier if there were two different tokens, but the same token has two different functionalities. You get to make decisions around the smart contracts, and you get to make decisions around the treasury. Now, that depends on the DAO. Like I said at the beginning, there's thousands of different potential permutations of this. And so just taking it at a high theoretical level, if there's a clear delineation of your ability to impact the decision-making and the outcome, then you're really talking about, separate processes. And so the potential to wrap them and have them be the appropriate place to pay tax, to limit your liability. It's kind of a half measure in terms of a fully wrapped, because whatever you don't wrap is going to have the same problems that exist to the regimeless that's talked about in the paper, almost talked about by Miles. But it's certainly a planning opportunity depending on how a DAO wants to proceed. If they're not interested in fully wrapped, or they have a particularly risky aspect of their operation, then this might be a solution that keeps them from having to unwind the UNA if laws get better, or to just keep it in the place that makes the most sense for them. So it's just it's a flexibility contained within DAO operations and the UNA that kind of provides a little more choice in how it can be applied.
Okay, so then there's just a couple things on practical applications, next steps, right? So we talked a bit about sub DAOs already. Safety modules is an area that we're kind of currently exploring. I think that this would be a pretty interesting way to essentially compensate governance token holders if you were to basically set up a safety module where the governance tokens were staked and would be slashed for potentially covering any losses created by the protocol. If you then compensated the people that were staking the tokens, that would not be a distribution of profits to the members of the UNA. So I think both from a securities law perspective and from a UNA framework, that safety modules are something that people should really be working on and iterating. Maker, I guess, already has kind of one, in a sense that the Maker token itself out of the treasury is used to to underwrite some of the risk associated with shortfalls and liquidations and collateral. But obviously the way that that's currently set up doesn't involve kind of compensation going to token holders for specifically assuming that risk. I mean, I guess you could make that argument, and that would be the one that you would want to make. But obviously there are examples of safety modules such as Aave's that show a little bit more direct correlation between the risk that the governance token holders are taking on and the what they're being paid to do so. We are actively working with state legislatures right now to get the UNA statutes expanded to make them more flexible for DAOs. So I expect 2022 to be a fairly big year in getting that through, and I'm hopeful that we'll get a couple states to go through. And then another thing that we're kind of focused on is how DAO tooling can basically be tailored to UNAs to allow them to work. Obviously, I think most of the stuff that the DAO tooling is kind of geared towards now, in sense of decentralized structures, works with the UNA. And I think that we'll obviously be releasing a lot of stuff for UNAs and making it open source, such as forum articles of association and things like that, so that if people that are interested in these structures really will have the tools to then implement them. So that's everything we got, Juan. If we want to open up for questions now, I think we've got a few minutes left.
Let's do it. So Paper mentioned that he doesn't have a microphone, but he has two questions. Can a UNA own another entity that does have a equity, such as an LLC, a corporation, etc.? And also, can a UNA later transition to a more formal profit-seeking entity if it matures and decides to distribute profits?
Yeah, good question. So yes, they can hold, UNAs are allowed to hold property, right? And as a result of that, they would technically be allowed to hold shares in a corporation, right? And so we think that works. There aren't a lot of examples of it. So that is an area that we would be kind of seeking clarity on when we go to state legislatures to deal with these statutes. And then on the second question, right?
To jump in on the first point though, that they may be able to own an entity, but that entity would not be able to distribute profits.
Correct.
And so it have to be consistent with its operational structure. So you would own a C corp. That C corp would not be imputed with the right to have member distributions. It would have to follow the restrictions of the unit that owned it.
That's right. And then on the second point around the dissolution and moving to a more a profit distributed structure, there technically are dissolution kind of components to the UNA statutes that we've been looking at. So theoretically that's possible. I think the difficulty that you would have, right, is finding a workable legal framework in which you could then accomplish that. And so if you didn't have something better to jump into, it might be difficult to leave the UNA structure. So that's another area we're going to be trying to work on with state legislatures to try and get more clarity around how you could dissolve an UNA if you wanted to move to a for-profit activity, including distributions to members.
And
Nice.
I think clarity on what profit is something we're hoping to get from legislatures, because obviously member distributions are violative of securities law. We've talked about a bunch, but Miles was talking about the self-insurance possibilities. There are mechanisms where members are making contributions to the community where they should be compensated for their time. And so getting a delineation of what is and is not allowed will provide clarity and help DAOs make planning decisions around what they should be doing. Because right now it's an unknown space, and that's where some of this difficulty comes from. Is every ability to derive profit or income or the tracking of how value gets transferred is hugely important given the risk structure right now. And if we had a little more clarity on what was allowed and what wasn't, then this wouldn't be such a time-consuming process. We just have some instructions on how to act and conform ourselves to that behavior.
Yeah,
absolutely. Last question goes for Robin, since we're at the top of the hour.
Thanks, Miles, for clarifying how tokens would be used as safety modules. So what you said is if we use safety modules, tokens can support the foundation and foundation can pay in return for that risk, right? And when we talk about exchanging of the tokens or selling and buying on secondary market, will the governance tokens be always considered as securities, or that's it depends? In certain cases, it might not be considered as security.
No, I mean our entire framework that we're focused on, right, is that the tokens should not be treated as securities, right? I mean, obviously I think that the UNA structure that we're proposing, I don't think really impacts the analysis as to whether or not the tokens are securities. Ultimately, what it does do, if you were to take the view that potentially the centralized foundations that kind of act on behalf of DAOs, if those were to be come under fire for potentially undermining decentralization, the UNA certainly doesn't have that same problem. There's no hierarchy that you need to create within the Articles of Association that would potentially lead to a finding that the overall structure is centralized, and as a result, the UNA structure shouldn't kind of hurt any decentralization analysis, which is the key for determining whether or not the tokens are securities. And with respect to safety modules, I don't think that the obviously, again, there's no kind of case law that is directly on point, but theoretically, right, if you are, it is not the case that paying people for services would indicate that the governance token is more likely to be a security. And so from my perspective, I do think that if you were to, set up a safety module and pay the people a market rate for the assumption of risk that they're taking, that wouldn't affect the securities analysis, because that shouldn't be deemed to be a distribution of profits to members.
Nice.
Thank you.
Miles, David, this has been great, really. Where can people find the memo, the paper that you've produced?
So I can send you, do you want me to drop it in right now?
Well, yeah, we can add it in the show notes.
Let me see here.
And if anyone has any questions watching later, what's the best way to reach you, or not to reach you, I guess?
We're pretty active on Twitter, a little less so these days than when we first put out the memo, but we try to respond. Kinga and I were talking off of Twitter last night, so we'd met before this call, and so we do. We're around. So if you reach out to us on Twitter, we'll answer back, and it's always good to discuss this stuff. So we're pretty accessible from a Twitter perspective.
Yeah, I've dropped
Sounds great.
I've dropped my handle in the chat if people want it. I've also dropped a link to the article. Perfect.
We'll add it there. Thank you very much, guys, for coming. It's been great.
All right. Thanks all.
Yeah, thanks for
Have a nice
having
one.
us. Bye, everybody.
Bye.